And this takes us to a fundamental document for the modern practice of precedent. As I was trying to stress, the statement from Lord Halsbury comes from some time ago, 1898. The point of law that I want to look at now, though, takes us to relatively more recent times, and that is the practice statement of 1966, which defines, as I've been trying to outline, the modern practice of the House of Lords. And it's worth just reading through some of the main ideas and thinking about the main ideas in the 1966 practice statement. So this first quote, in fact all the quotes that follow come from the 66 practice statement. Quote, "Their Lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides at least some certainty upon which individuals can rely in the conduct of their affairs, as well as a basis for the development of legal rules." I've edited this thing. This is the next point I just want to draw your attention to. The practice statement says, "Their Lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law." So this begs the question, when are their Lordships going to not adhere rigidly to a precedent because it's causing injustice? There are certain things, certain factors that their Lordships must consider, and they do outline this later on in the practice statement. They draw our attention to the danger of disturbing the basis on which contracts, settlements of property and fiscal arrangements have been entered into, and also the especial need for certainty as to the criminal law. Now, let's just review these arguments. Let's go back to that first quotation. Clearly, what their Lordships are saying in the 66 practice statement is they're not going to depart from precedents on a whim, or when they feel like it, or when they've had a bad lunch or something like that. There has to be a principled approach to this issue. They affirm, first of all, in the first sentence of the practice statement, that precedent is an indispensable foundation. That's clearly drawing our attention to the fact of its fundamental importance. Note as well what they say. It provides at least some certainty, not absolute certainty. We can't have absolute certainty, at least some certainty, upon which individuals can rely in the conduct of their affairs, as well as the basis for the development of legal rules. To pick up on one point here, we're clearly talking about judicial lawmaking. These are the rules that the senior members of the judiciary will follow when they are presiding on important cases. The next key point is this. Their Lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case and may also unduly restrict the proper development of the law. Now, if one reads this in the light of what Lord Halsbury is saying in that earlier case, we can see that the 1966 practice statement completely changes the law. Lord Halsbury is saying the injustice in a particular case is not important. It's not an important consideration. The 1966 practice statement is saying almost complete opposite. Their Lordships recognise that too rigid adherence to precedent may lead to injustice in a particular case. So we could say one of the considerations here is the need to do justice in a particular case and also unduly restrict the proper development of the law. In other words, unnecessary adherence or too rigid adherence to precedent will mean that the common law does not develop in a flexible way. So we still need some guidelines, don't we, to say what important factors must we consider when we are, or when the law lords are trying to determine whether or not to depart from a precedent ruling, from a previous ruling of the House of Lords. Here's the basic guideline. The danger of disturbing the basis on which contracts, settlements of property and fiscal arrangements have been entered into, and also the especial need for certainty in the criminal law. So we've got two sets of considerations here in summary. The need for certainty in the criminal law, and obviously then those considerations in areas of law that are not criminal law, in areas of law that are civil law, contract law, settlements of property and fiscal arrangements. People obviously need to be sure that the legal arrangements that they've entered into are valid and current and would only be disturbed in absolutely exceptional circumstances. So what would be those exceptional circumstances? Well, perhaps the key case that might illustrate this point for us in a neat fashion is a case called Miliangos and George Frank, decided in 1975. Now, I want to look at Lord Wilberforce's argument in this case because it picks up on the terms of the 1966 practice statement, and it's going to give us some indication of when, in this area of civil law, judges will, or the House of Lords, Law Lords and the House of Lords, will depart from a previous ruling. Now, the previous ruling in this case was in a case called Havana Railways, and it concerned the so-called sterling damages rule. In other words, when a court gives judgment, it gives the judgment in sterling, so your damages would be paid in sterling as opposed to US dollars or euros or any other currency. This is a problem. It's a problem for a number of reasons. We haven't got time to rebuild the context of this case, but as you might guess, it has a lot to do with the fact that sterling becomes less and less important as a world currency and the US dollar becomes more and more important. This is 1975, remember. Let's keep that context in view, but I'm more interested in the legal argument that takes us back, if you like, to the terms of the 1966 practice statement. This is Lord Wilberforce, or a passage from Lord Wilberforce's judgment. Quote, "The law on this topic is judge-made." The topic, remember, is the sterling damages rule. "The law on this topic is judge-made. It has been built up over the years from case to case. It is entirely within this House's duty, in the course of administering justice, to give the law a new direction in a particular case, where, on principle and in reason, it appears right to do so. I cannot accept the suggestion that because a rule of law is long established, only legislation can change it. That may be so when the rule is so deeply entrenched that it has infected the whole legal system, or the choice of a new rule involves more far-reaching research than the courts can carry out. Indeed, from some experience in this matter, I am led to doubt whether legislative reform, at least prompt and comprehensive reform, in this field of foreign currency obligation is practicable. Questions as to the recovery of debts or of damages depend so much upon individual mixtures of facts and merits as to make them more suitable for progressive solutions in the court. I think that we have an opportunity to reach such a solution here." End of quote. Let's just review the main terms of Lord Wilberforce's argument. He starts by saying that, remember, he's trying to justify why it is acceptable in these exceptional circumstances to depart from the sterling damages rule. So what key factors is he drawing our attention to? First point, the law on this topic is judge-made, i.e. it's primarily been made by the judges on a case-by-case basis over the years. There's not much legislation here of direct relevance. Therefore, it would seem to follow, wouldn't it, as Lord Wilberforce argues, that it's within the House's duty, the House of Lords this is, in the course of administering justice, in the course of deciding cases, to give the law a new direction, because on principle and in reason, it appears right to do so. Now, note what he then goes on to say. He's really arguing against the idea that the courts should wait for Parliament to change the law. So he says, I cannot accept the suggestion that because a rule of law, because a rule is long established, only legislation can change it. Note this is a caveat, it's a qualification to his own argument, isn't it? This may be so, in other words, Parliament may change the law, when the rule is so deeply entrenched, in other words, so much part of a given area of law, that it has infected the whole of the legal system. It's an interesting metaphor, it has infected it. In other words, the wrongness of a particular statute is so profound that the whole legal system, it's a very strong statement, has been affected by the incorrectness of those legal principles. In other words, then Parliament can legislate. But this is not that kind of Miliangos, the facts raised by Miliangos and George Frank don't raise that kind of fact. Then there's an alternative argument put forward by Lord Wilberforce. Or, the choice of a new rule involves more far-reaching research than the courts can carry out. Now, this is another good point, isn't it? Parliament, as we know from previous lectures, has the primary lawmaking function. It can call on much greater resources in order to carry out this function than the courts can. In other words, if we're looking at major policy changes, the courts are inappropriate for this to take place. Think about it. The courts hear an argument, two partisan arguments from either side, and they decide the case on the basis of the evidence provided in front to them by two partisan parties. This may not be arguably isn't the best way of making general law. It's a good way of making legal principles, but in terms of changing general policy, it might not be. In other words, the courts or the judges' lawmaking function is a profoundly limited one. The judges accept this. So this would also be an argument that in certain cases the House of Lords should not depart from a previous decision, should not, if you like, try and change the law, because it should be left to Parliament. However, on the facts of this case, this is not this kind of situation. Lord Wilberforce then appeals to his own experience in the matter, argues that legislative reform would not be appropriate, partly because of the mixture of facts and merits make this more suitable to a solution in the courts, which I think is, it's the opposite kind of argument to the argument I was just outlining. There are some forms of dispute and some forms of creation of rules and principles that are more fitting to the work of the judge than the policymaker or Parliament, and the Sterling damages rule falls into that category. Okay, so what have we been thinking about? We've been thinking about the 1966 practice statement, and we've been using Millie Angos and George Frank to try and think about those rather limited circumstances where the House of Lords would depart from its own previous rulings. We also looked slightly earlier on at Lord Halsbury in London Tramways and London City Council, and I wanted to stress when we're looking at that case that it's from 1898, and that's a different way of looking at the hierarchy of the courts. The modern practice is defined by the 1966 practice statement and cases such as Millie Angos, where their lordships have given strong arguments for which justify, in certain limited circumstances, those instances, and we've only looked at one of them, there are others which I'm not going to talk about, where it is entirely legitimate for the House of Lords to depart from its own previous rulings.